Good morning from London to all of you who are joining us today. We would like to welcome you on behalf of BICL to this conference day on international commercial courts, where we want to take stock and look at the development of these courts, at how they have been dealing with international cases, and also how they cope with challenges such as COVID-19, digitalization, and AI. Xandra Kramer, who is here with me today, and we organized this conference in cooperation with the University of Rotterdam and the University of Lausanne. And this event is funded by the European Research Council, and we are very grateful for the financial support. I just wanted to give you a bit of background because we planned this conference nearly 2 years ago. And I still remember Xandra and we were on the phone wondering in early 2020 whether we can hold this conference in summer. And little did we know how many times we had to postpone it. Obviously we can't see you all live still here in London, but we are very happy that we could put the event together and at least have very interesting discussions with all of you today. So we look very much forward to this conference day, which is also a sort of continuation to a very nice conference Xandra has organized in Rotterdam in 2018 on the topic of international commercial courts. And so we very much look forward to it. I briefly give the floor to Xandra, who also would like to say a few words of welcome.
Good morning, everyone. I'm happy to be here. A warm welcome on behalf of myself, of course, and my team in Rotterdam. Though today I'm very happy to be in London here with Eva and one other speaker who's also here in the room today. Despite a little bit of a hassle of travel coming here and having additional tests apart from the vaccinations, I enjoyed. I'm happy that I'm here. Yesterday when I had a dinner here and walking around the city and coming here this morning, I realized it was worthwhile to come over here. And it was my first business travel in over a year and a half. As Eva mentioned, we had a seminar on international business courts. That was in July 2018, when all the courts in Europe were just starting or about to start. And also after that, we had a couple of smaller events around these courts. International commercial courts are also part of the project that Eva mentioned, financed by the European Research Council under its consolidator scheme, Building EU Civil Justice. And my PhD candidate, Georgia Antonopoulou, wrote her PhD, which is about to be finished on this topic. And I'm happy that she also joins us today as a speaker and is also live here because as of this month, she moves from Rotterdam to Birmingham University to continue her career. Today, our focus is on the new established business courts in Europe and Asia. But of course, we acknowledge that also some courts have been set up in other parts of the world, most notably in the Middle East, Qatar and Dubai, which were even a bit earlier than the European countries that established it in the last few years. I think this topic of international business courts is very fascinating, and it's also because it's very multifaceted. There are two main perspectives that we can distinguish here, but you can really approach it from many different angles. My two main perspectives are always either court specialization or international dispute resolution. And of course, court specialization at the national level is really nothing new. We have that in many areas. And for instance, the French commercial court, Tribunal de Commerce, was already set up in Paris in 1563 and was actually the first court and the oldest court in the French judiciary. And also, of course, the London Commercial Court that since 2018 has been renamed the Business and Property Courts, had been established already in 1895. So in that sense, nothing new. Court specialization, of course, has certain advantages, offering tailor-made procedures for certain types of disputes, and today, for our case, business-related cases. Of course, this is considered to enhance efficiency of the procedure, but also, and that's very important, to give a better quality of procedures and of court decisions because of specialization of judges. But it has also been criticized or certain disadvantages, including that it might create a certain tunnel vision, create a monoculture, or two-tier justice system. And the latter is perhaps also something that we will hear in our first panel when the Belgium initiative that didn't really work out will be discussed. The other perspective, which is also very interesting, is of course, because we're talking about international business courts, is international dispute resolution. And we all know, and survey research, but also our own experience shows that in a majority of cases, in certain areas of business, parties prefer arbitration. But arbitration is not always an option, especially for medium or smaller parties. And then it is good that we have these international business courts now as an alternative, and also as a court within the public system where parties can also choose to go, which offers the similar expertise, and of course also offer the possibility to litigate in English, have more flexible rules, and also of course hopefully to obtain a judgment within a reasonable period of time. Also from this perspective, and that is also what has boosted some of the courts in recent years, is the competitive advantage or the economic perspectives that comes in here. For instance, the World Bank doing business reports have considered having a commercial court as promoting a good business and trade climate, and also similar considerations are seen in EU policy documents. Of course, we also know that in Europe, the establishment of these courts have also been boosted by the Brexit vote, though all of the initiatives already started in the years before. But the idea was then to give it a little bit of a push, setting up these courts, because making perhaps London less attractive as a litigation hub would create opportunities for other countries. Whether that has materialized or will materialize can be doubted. In any case, after a few years of having experience with these courts, the time has come, and that's also the title of our conference, to take stock. Do these new courts really bring something new to the table? Also looking at their first years of operation, what is the interface with arbitration, which these courts have also been looking at, and in how far do these courts really innovate justice and also face up to the global challenges, including, of course, the pandemic. I'm now very happy to give the floor back to Eva to introduce our keynote speaker, who was also at our seminar back then in 2018, and we're very happy to have him again today.
So we are really very pleased to welcome Sir Geoffrey Foss, who has kindly agreed to be our keynote speaker today. He has served as Master of the Rolls since the beginning of 2021. Before that, he was a judge of the Court of Appeal of Jersey and Guernsey, a judge of the Court of Appeal of the Cayman Islands, a Justice of Appeal for 3 years, and also the Chancellor of the High Court from 2016 to 2021. Before he started his career as a judge, he was called to the bar at Inner Temple in 1977 and took silk in 1993. It's also very interesting that he is looking forward and is very interested in digital justice. So in his role as head of the civil justice system in England and Wales, he's also leading the digital justice reform, which is a topic that obviously interests us today as well. We would invite the audience as well to ask questions. We will collect the questions during the speech, and please put them in the question and answer section. We will then read them out to Sir Geoffrey after his speech. So thank you very much, Sir Geoffrey, the floor is yours.